Welcome, everyone. I'm Stephanie Summers, the CEO of the Center for Public Justice. Thanks for joining us today for our webinar, Will the Senate's Respect for Marriage Act Protect Churches and Religious Organizations? A brief agenda for our hour together. I'll introduce our topic, have a series of questions for our panelists, and then we'll turn to you for your questions later on in our program today. So throughout our discussion, drop your questions into the Q&A portion that's located at the bottom of your Zoom screen so we can turn to some of them later on. And my apologies in advance if we're not able to get to every question today. Let me turn to a brief introduction for our topic. The Center for Public Justice is a nonpartisan Christian civic education and public policy organization. We're committed to public policy that promotes justice and the common good by ensuring respect for the deep convictions of all. And thus, CPJ has a deep interest in an effort in Congress to ensure that any congressional action on marriage includes strong religious freedom protections. All of the organizations represented here today have strong commitments to marriage between one man and one woman. And all of the organizations here today have also been publicly supportive of the Senate's bipartisan substitute amendment number 6487 to the Respect for Marriage Act, which adds important religious freedom protections to the bill. So let's turn to our panelists. Dr. Stanley Carlson Tees is the founder and senior director of the Institutional Religious Freedom Alliance, a division of the Center for Public Justice. As part of his role, he convenes the Coalition to Preserve Religious Freedom, a multi-faith alliance of social service, education, and religious freedom organizations that advocates for the religious freedom of faith-based organizations to Congress and to the federal government. He served with the White House Office of Faith-Based and Community Initiatives from its inception in February 2001, and has worked with the subsequent 4 presidential administrations on the continuation of the faith-based initiatives. Welcome, Stanley. Joy Mosley is the Associate Vice President of Government and Strategic Relations at the Council for Christian Colleges and Universities. She graduated from and subsequently worked at Covenant College for over 10 years, where she was the Senior Human Resources Partner before departing for law school. Joy received her Master of Business Administration from Belhaven University and Doctor of Law from Emory University. Welcome, Joy. And lastly, Alexander Dushku is a shareholder in the Salt Lake City law firm Curtin McConkie, where for many years he was head of the firm's constitutional and appellate law sect, specializing in appellate brief writing, critical law, and motion practice. He has authored numerous briefs in important religious liberty cases before appellate courts across the United States, including the U.S. Supreme Court, and has consulted with legislators and advocates across the country on religious liberty issues. He is lead outside counsel for the Church of Jesus Christ of Latter-day Saints in matters of religious freedom, public policy, and First Amendment law. Welcome, Alexander. All right, so let's jump right in. Stanley, starting with you, what is the Respect for Marriage Act that the Senate's considering, and why is there so much concern from some religious circles about it?
Well, a Respect for Marriage Act was passed by the House in July, and it would require the federal government to recognize as valid same-sex marriages as well as opposite-sex marriages from any state, and then require every state to respect same-sex marriages from other states, although they wouldn't have to license those marriages themselves. The Respect for Marriage Act being considered by the Senate, though, would add to that a series of strong protections for religious freedom. So I want to say more about those protections and concerns about them and about the current state of the Senate's action in just a moment, but I thought a little background would be helpful. You know, same-sex marriage was legalized first in this country in 2004 through a decision of the Massachusetts Supreme Judicial Court. And immediately, everyone concerned about religious freedom said this could be a problem for religious people, religious organizations. Just a couple of years later, a path-breaking and still excellent book was sponsored by the Becket Fund for Religious Liberty, Same-Sex Marriage and Religious Liberty, Emerging Conflicts. And we've seen those, in fact, emerge. Well, what's it say if you say that same-sex marriage and religious freedom are in conflict. Well, actually, what people are saying is if same-sex marriage is the law, if that's the legal definition of marriage, it can be opposite sex, same sex. What happens to religious believers and organizations that insist that God defined marriage instead as a union of one man and one woman? Will such people be hounded out of their jobs as bigots? Will their religious nonprofits lose their tax exempt status? Will a Catholic adoption agency be required to place children in with a same-sex married couple? Will an Orthodox Jewish synagogue be excluded from security grants that are supposed to protect them from terrorist acts, but because they've got these supposedly backward convictions about marriage and so on? So all these questions have come up. And as it happens, various states after Massachusetts that passed same-sex marriage laws through their legislatures also included various protections for religious people and organizations. But then the Supreme Court stepped in 2015, as we all know, in the Obergefell decision, requiring every state, including those that hadn't done anything legislatively, to license same-sex marriages, but without requiring every state also protect the freedoms of dissenting religious organizations and people. So that's kind of where we have been. Well, so there's that Supreme Court decision. Why is Congress even thinking about this topic? The spark was, ironically, the Supreme Court's decision in the Dobbs case overturning Roe versus Wade. That was about abortion, of course, not about marriage. But Justice Clarence Thomas, in his concurring opinion, said, well, that's not the only thing that I think we decided on the wrong basis. There's also Obergefell and some other decisions. Maybe we should revisit that. And immediately, a lot of LGBTQ advocates said, that's dangerous. We should get Congress to step in and on a legislative basis say we're going to protect same-sex marriage. So the House passed that kind of bill without any religious freedom protections. Besides a yes from all the Democrats who voted, 47 Republicans voted for it, but there were no religious freedom protections despite all these years of concern about that. The House bill then came to the Senate and has just sat there. As you know, the Senate is divided 50-50, and because of the filibuster, anything important that's going to move needs 60 votes. That means 10 votes from the other side, and there just weren't 60 votes for a same-sex marriage law that did not protect religious freedom. But what is now moving in the Senate is an amended House bill with these religious freedom protections, a bill championed by Republican Senator Susan Collins and Democratic Senator Tammy Baldwin. And it's well on its way to being approved. Just before Thanksgiving, 12 Republicans joined Democrats to forestall a filibuster when it came to just considering this topic. And then last night, by a vote of 61-35, the Senate voted to take up this amendment, the amended Respect for Marriage Act, the one with religious freedom protections in it, again, without the chance of a filibuster. And there's supposed to be scheduled to be this afternoon a vote on that bill. So that's happening fast, but it's after many years of discussion about all these issues. There'll be some other amendments voted on this afternoon as well. And then there'll be the Senate vote on the Collins-Baldwin bill with religious freedom protections as well as the gay marriage parts of it. You know, when those two senators, again, a Republican and Democrat, announced their amended version, they proclaimed that it included multiple strong religious freedom protections. That additional language came from their own offices, and it also came from the contributions of Senators Portman, Sinema, a Democrat, Senator Tillis, another Republican, and from the advice of outside advocates, including CPJ, IRFA, the Church of Jesus Christ of Latter-day Saints, Alexander, and others, who said, if you want to protect religious freedom, this is what you have to do. And there were some gay rights advocates that are also believers in the First Amendment, strong advocates that worked on that. But despite all of that, as you all know, there's been persistent claims that the supposed religious freedom protections are weak or even meaningless. And that's why we have this webinar to discuss those protections. Are they weak or strong? Okay, just one other comment. Others have a somewhat different concern, I think. They say that because same-sex marriage is not God's design for marriage, it's wrong for Congress to pass a law like this. The Supreme Court did what it did. It's wrong for Congress to chime in. I think that's a serious issue, even though our marriage laws already depart a lot from a biblical standard, right? no-fault divorce is not a biblical design for lifelong commitment between one man and one woman, but it's still important what Congress does. But I think we all have to think about this. What do we do in a democracy that passes laws when the majority now does not believe that God's design is the way marriage has to be, but instead believes in marriage equality? What kind of stable protection can there be in just saying, don't do this? Or do we have to say, whatever you're going to do, make sure that people who believe differently can freely believe as they believe God calls them to do? And that's kind of where we are now with the Senate bill that's going to be voted on this afternoon. I'll stop there.
Thank you, Stanley. All right, Joy, turning to you, let's get you in this conversation. So I know that the Council for Christian Colleges and Universities has spoken out in support of the religious freedom changes that are in the amended version of the Respect for Marriage Act. Marriage doesn't seem so central to the work of Christian colleges and universities. So can you say why the CCCU has spoken up about this and why it is important to your member religious institutions?
Sure. Thanks, Stephanie, and thanks for inviting me to be a part of this conversation. So I think it may be helpful for me to give some background on the CCCU first, for those of you who may not be as familiar with our work. So the CCCU is a higher education association that represents over 185 institutions around the world, including about 145 in the US. Our institutions enroll approximately 520,000 students annually, with over 3.6 million alumni. Our mission is to advance the cause of Christ-centered higher education and to help our institutions transform lives by faithfully relating scholarship and service to biblical truth. So we're committed to graduating students who make a difference for the common good as redemptive voices in the world. And as the national leading voice for Christian higher education, we provide a unified voice to highlight the contributions of our institutions and of our students to the common good. So our advocacy priorities stem from this desire to support our campuses and our students, our staff and our faculty. We work to ensure institutional autonomy and religious freedom for all of our members. We support the expansion and continued support of Pell Grants. We support charitable giving at all levels for individuals because private institutions rely on these programs to provide aid and opportunities for students. Many CCCU institutions offer prison education programs to support and empower incarcerated individuals through learning. Our immigration initiatives work for permanent protection for dreamers and restitution-based immigration reform and a welcoming environment for international students. So as you can see, we advocate for a number of issues, but the right of each CCCU institution to practice its sincerely held religious belief and participate fully in the public square without penalty, that's the key issue for the CCCU. And so CCCU institutions hold the biblical beliefs that are often countercultural. One of those beliefs is the traditional biblical view of sexuality and marriage. Advocating for this belief is important to the CCCU because we believe the Bible is the authoritative and infallible word of God, and God's design for his people is central to Scripture. A biblical understanding of sexuality and marriage is important for Christian higher education because it informs things like hiring decisions, housing arrangements, community covenants, and expectations. So the CCCU is a strong advocate for robust religious liberty protections, which includes, but is not limited to, marriage. And so while we do not support the bill itself, as the Respect for Marriage Act, the RMA, moves through Congress, we've worked with other religious liberty partners to ensure that it must pass with religious liberty protections that protect those who hold the traditional view of marriage.
Great, thank you, Joy. That's really helpful. Alexander, could you talk a little bit about the concerns of some devoted religious freedom advocates that the bipartisan changes that have been made to the Respect for Marriage Act in the Senate do not actually protect religious organizations and people who are committed to traditional marriage? And could you do that, start by telling us kind of why the Church of Jesus Christ of Latter-day Saints has spoken out so strongly on this issue in particular?
Certainly, and I'm grateful to be here. I think, as many of you know, the Church of Jesus Christ of Latter-day Saints has long supported the traditional biblical understanding of marriage and supported that in law. It was heavily involved in the Proposition 8 campaign back in 2008 in California, which put that definition into California's constitution. Of course, there's been a sea change since then, and the United States Supreme Court has ruled that same-sex marriage must be recognized by the government. What we faced, as Stanley so well laid out, was a bill, the Respect for Marriage Act, that came roaring out of the House of Representatives with no religious freedom protections, no acknowledgement that there are other views about marriage, family, and sexuality, and so forth. And that then landed in the Senate. And so that was a reality that we had to deal with. It was not a reality that we that we chose, but it was a reality that we had to deal with. And so we have worked with other religious organizations, conservative religious organizations who support the traditional biblical understanding of marriage, to try to strengthen the bill by adding religious freedom protections. And those protections are indeed real. Let me just tick off a few of them, and then we'll no doubt have an opportunity to discuss them in depth. First, these religious freedom amendments clarify that the Respect for Marriage Act does not reduce any federal or constitutional protection for religious liberty. Now, this is important because federal law already contains a very powerful protection for religious liberty. It's called the Religious Freedom Restoration Act. And that has a very, very powerful religious freedom standard that is extremely difficult for the government to overcome. So the Respect for Marriage Act amendments clarified that that would not in any way be undone, which is something that sometimes LGBT rights advocates have demanded. That would remain firmly in place, and all other protections for religious freedom in federal law would remain in place. So we begin with this strong statement that this is not going to diminish religious freedom. Second, the Respect for Marriage Act amendments make very clear that the Respect for Marriage Act is not going to adversely affect any federal status or benefit. And then it lists a number of those benefits, and they include expressly tax-exempt status, educational funding, grants, accreditation. There's a long list of these benefits that kind of flow from the federal government, including tax-exempt status, as I mentioned, that are not going to be affected in any adverse way by the Respect for Marriage Act. That, of course, has been one of the concerns that has been raised, and we were very grateful for that, because without that, there could be an implication, at least, that the government was establishing some kind of national standard that would affect tax-exempt status. But no, the amendments say very explicitly that it doesn't do that. Third, and this was really a powerful provision that we did not expect to be able to get. The amendments to the Respect for Marriage Act provide that religious organizations, and this includes religious schools, is very important, don't have to solemnize or host or serve or accommodate in any way same-sex weddings, marriages, or related celebrations. Now, this is significant if you think about religious schools that might have facilities that are used for wedding receptions, for example. They will have the right under this provision, which we believe applies not just to federal law, but also to state law and to local law. They will have the right to host only, to accommodate only marriages that comply with their religious beliefs. And then finally, and this is a provision that's not been paid much attention to, but it's very important. There is an express congressional finding that good people can have good beliefs about traditional marriage. In other words, that traditional marriage beliefs are held by people who are decent and honorable, and that those beliefs themselves are decent and honorable. Now, why is that important? It's important because it is rebutting the notion that traditional religious believers in marriage between a man and a woman are somehow bigoted, that they are somehow acting out of ignorance or some dark and sinful or evil motive. Quite the contrary. Congress is expressly finding that there can be different views on these kinds of issues, and that those people are entitled to respect, that we are entitled to respect. That is the very opposite of the charges that we sometimes hear, of course, that those who believe in the traditional definition of marriage are somehow bigoted. So all of these things, this entire package is really quite significant. And it's especially significant because the scope of the Respect for Marriage Act itself is targeting government and government officials and those who work directly for the government as the government. In other words, the Respect for Marriage Act is not reaching, every single actor that's out there, every private individual who's out there. It is targeting the government. And yet we have layered on top of that a series of religious freedom protections that are indeed quite robust.
Great, thank you. Alexander, I know that I've just put you on the spot. I'm going to put you on the spot again, but a question that we're getting asked a lot is what happens to Jack Phillips? You raised this thing about government. What happens to Jack Phillips, the Colorado wedding cake baker? What about people of faith working in secular businesses as employees or religious owners of non-religious businesses? What happens to those folks?
Yeah, well, the Respect for Marriage Act doesn't affect them. It doesn't apply to them. It only applies to those who are government officials or those who are acting as if they were government officials. So for example, if you run a company that's running a prison and you're acting on behalf of the government in operating a prison, well, then you would be subject to the Constitution already. You'd be subject to the Obergefell decision. You'd be subject to all the other rights in the First Amendment and in the 14th Amendment to the United States Constitution. And hence you would also be subject to the Respect for Marriage Act. But those situations are extraordinarily rare. Jack Phillips, of course, is a private business owner. He's a private man of faith who is operating his personal business. He is not a government actor, and therefore the Respect for Marriage Act doesn't apply to him in the first place. He has nothing to worry about whatsoever from the Respect for Marriage Act. Again, it's targeting government. Okay, it's ensuring that the state of Utah, for example, if Obergefell were to be overturned, if the gay marriage decision were to be overturned, that the state of Utah, notwithstanding its own views on this, would still have to recognize same-sex marriages from the state of California. That's really what this is about.
Great, thank you. Just a reminder, we're getting some good questions here in the chat, but please don't take that as an inhibition to put your questions in there. We're trying to make sure that we create the best information for people. So even if we can't get to all the questions today, we want to be able to answer and address the questions. So go ahead and drop those in the Q&A located at the bottom of your Zoom screen. I'm going to turn to Joy. Joy, isn't there a way for senators who want to protect everyone in the public square to get broader religious freedom protections beyond those related to same-sex marriage into this bill?
Yes, I think there is an opportunity for broader religious freedom protections, but I'm not sure that this bill is the most appropriate vehicle. So I have heard some religious freedom advocates opine that the religious protections in the RMA are more narrow and do not cover other concerns like employment, housing, public accommodations, etc. And because the RMA is narrowly tailored to include only marriage, the religious liberty protections are then appropriate to the bill. Those religious liberty advocates want more protection. I want more protection. The CCCU supports broader religious freedom protections as well. We've actually been working for a number of years to ensure those broader protections. Many of you are familiar with the Equality Act and the harms that it would impose on people and institutions of faith. There is a better way, and we believe that the Fairness for All approach can address the LGBTQ civil rights, but paired with robust religious liberty protections. The USA is a pluralistic country by definition, so the CCC presses for values in line with Christian commitments because we believe those commitments are best for everyone. But we also recognize that the world is not the church, and that ultimately each person is accountable for their own actions before the Lord. Extending basic legal rights to all people, including LGBTQ people, in such areas as housing, jury service, credit, employment, does not mean that we affirm or equate same-sex marriage with traditional marriage. Rather, it reflects that in a pluralistic society, it is possible for people to have different beliefs and find a way to live together. Fairness for All evidences that those things are possible for civil rights to be extended to LGBTQ persons and for Christian institutions to remain faithful to their convictions. Something like this creates a path forward where Christian institutions can live at peace with their neighbors while continuing to be beacons of truth, holding faithful to their religious beliefs, hiring for mission, and proclaiming their faithful witness. Many, if not all, of the protections that the religious liberty advocates who oppose the RMA amendment say is needed are included in the Fairness for All bill. So we agree with them that broader protections are needed, which is why the CCC has been a leader in advocating for those broader protections for years. But we also believe that religious liberty protections are too important to rely on just one strategy. The CCC also advocates for these broader protections in the regulatory and judicial spaces as well. So for example, Alexander just talked about how the RMA does not cover every single dispute involving LGBTQ people and religious people, such as the famous cake baker situation. This question, though, is currently being litigated in the 303 Creative case by our friends at ADF, Alliance Defending Freedom. Lori Smith is being censured under the same Colorado law that was used to punish Jack Phillips. So the CCC led a brief in support of Lori Smith and her First Amendment protection to create websites in accordance with her faith. So yes, we believe there is a legislative way for the senators to enshrine those broad protections that all religious liberty advocates want, but we also need to be working in multifaceted ways to ensure that people and institutions of faith can continue to live out their faith to transform lives and communities for the gospel.
Great, thank you, Joy. My last question for our panelists, and then we're going to turn to your questions, which are great. So looking forward to getting to those. Stanley, going to give you the last question here. So the Supreme Court has ruled strongly for religious freedom in many cases. Wouldn't it be better or safer just to rely on the courts? Oh, you're on mute, friend.
Okay, sorry. I've been looking at some of the questions in the chat. There are some great questions, and I'm really happy that we're engaging in a real discussion about what needs to be done here, because I think sometimes this whole question is just kind of abstract, like what about this, what about this? But actually, all the real questions come up with real concrete situations, and so that's why I think it's important to have legislation and not just the Supreme Court. Supreme Court, as I said before, in the case of Obergefell, said we're going to have same-sex marriage across the country, and then it had just a little bit of language saying we're going to respect people who have different convictions. But the Supreme Court couldn't create those actual protections where they were needed, and that's why I think it's so important to have not just the guidelines for the Supreme Court, but actual legislation that looks at different situations. But a lot of the ones that concern us, as Joy just said, go beyond what's in this particular bill, which just has to do with marriage. What about these other questions that need to come up? And I think that's why we need to continue to advocate, work in the courts, and also regulatory on a wide range of things. The good thing here is that when the Supreme Court didn't put in specific protections, here Congress says that it's going to do that, and I think that's going to be positive for all of us. You know, there used to be in our society this very strong majority for traditional marriage, and then these questions didn't come up. Gay people felt like their rights weren't respected, but the law said we've got one definition of marriage. Our society has changed so much despite that law like that, and now the strong majority supports same-sex marriage. You know, any kind of marriage, two people, it doesn't matter. And those of us who think, no, God has a particular design, that's the way we would like to live, that's the way our organizations ought to act, we're the ones that now have to say to others, let us be free to protect and live by our kinds of conceptions, what we think God demands. And we'd like to convince you of that. We haven't done it yet. Let's convince you of that. So I think what this bill with its strong amendments does is give us space to make that argument, continue to make that argument. But it has all these difficult aspects to it. What is a strong enough protection? Can we trust government to do the right thing? Will organizations get attacked and so on? That's the life we live in this world, and here we're trying to stabilize by having strong protections in the law if Congress decides to pass something on gay marriage.
Let me mention something else, just agreeing with Stanley. The Supreme Court, of course, is the ultimate backstop and is extremely important. But to get to the United States Supreme Court is an enormous process. It takes years, it takes huge amounts of money. It is very often enormously traumatizing to faith communities and their religious organizations, religious schools, for example. And it is far better to have a very clearly spelled out protection in a statute that is so that if you ever get sued, you just point to the protection, you say, court, they can't sue us for this. Here's what the law says. And the court says, you're right, that's what the law says. And then they dismiss the case. That is vastly better than having to work all the way up to the Supreme Court to establish that very standard.
Great, thank you. All right, we're going to turn to your questions, and we're also going to share out to you a couple of links for resources that were mentioned or we think are helpful. One is the full text of the Senate amendment that we're talking about. Some folks in the Q&A have asked for the text, so that's here. The other piece is going to be leading religious liberty scholars talking about the religious freedom protections that are in the amendment. And then the third is a piece by our friends at the First Amendment Partnership responding to some of the criticisms that the amendment itself has received. So let me turn to some of your questions. And I know already we're not going to be able to get to all of them, but I'm trying to kind of bunch them together to get them as clear as possible. So we have a question from related to Christian colleges in particular. So the question is, if the Respect for Marriage Act is targeted to government and not all citizens, how does the bill apply to Christian colleges and organizations?
I can take that one. That'd be okay?
Yeah.
Yeah.
Well, first of all, it shouldn't apply at all to Christian colleges. That is the affirmative duty to recognize a same-sex marriage doesn't apply to a Christian college. Now, why? Well, because it is not a government actor. It is a private religious actor. And the Respect for Marriage Act doesn't cover private religious actors. And then, if that were not clear enough, it then incorporates into the act itself clarifications and protections to make doubly sure that they can't be attacked, that none of their federal rights are being stripped, none of their constitutional rights are being stripped. And so again, it just doesn't extend to private religious organizations like religious colleges.
And if I may chime in, kind of looking ahead to some of the other questions, to further Alexander's point, receiving federal financial aid like a Pell Grant or other educational funding does not make you into a government actor. Receiving government funds does not turn you into a state actor.
And for those who are worried about that, think about it this way. If what Joyce said were not true, and it's absolutely true, but if she were mistaken and that somehow receiving Pell Grants, receiving research grants and so forth turned a religious college into a state actor, then your religious colleges, those religious colleges would already be subject to the Obergefell same-sex marriage decision and could already be sued under the 14th Amendment to the United States Constitution. Well, that of course is not what's happening, and that of course is not accurate. And the Respect for Marriage Act doesn't change that. So you're still protected. You can still teach and act in accordance with your religious doctrines without any concern about the Respect for Marriage Act.
So I want to just add to that as well, that the state actor questions often come up in the case of religious hiring by a faith-based organization that gets government money. So critics always say, hey, you're doing the government's business by getting that money. And so your organization's a state actor, it can't hire based on religion because the government's not allowed to do that. And the courts have just said, no, that's not right. They're not state actors. they are doing something in partnership with the government. That doesn't make them a state actor. Even when, this was a New York City case, the religious entity got 99% or more of the funding for the thing it was doing from federal, state, and local government. And the court said, that doesn't make them a state actor. They're still a private religious organization. They've agreed to help out the government by doing these things. They're getting money for it. They're not a state actor. So this requirement for state actors wouldn't apply to them.
We've got tens of millions of people who receive Social Security checks. They don't automatically then become state actors merely by receiving money from the government. So
helpful. I'm going to stay on the Christian college theme for a second because there's a bunch of questions in here related to Christian colleges, and then we can switch to another topic. So if the Respect for Marriage Act supports religious organizations like Christian colleges, does it only apply to Christian colleges that are directly connected or governed by a denomination or a lead church, or will this apply to independent Christian colleges or religious colleges as well?
Yeah, the protections make no distinction between independent Christian colleges and those that are directly sponsored by a religious organization. Both would be able to invoke the protections under the Respect for Marriage Act. And neither would be covered by the Respect for Marriage Act anyway in the primary obligation. So they're double covered.
But that's a great question. And I think whenever we think about religious freedom in the government and are there protections or not, it's always good for religious organizations, whether they're governed by denomination or not, to really think about what is it they're doing and what are their beliefs, and are they carrying them out sincerely and consistently, and have they, made it clear in their founding documents and their policies and so on that they consider themselves a religious organization. I think days when groups tried to say, well, we don't want to appear too religious because then people would be against us. That's not a good game to play. You're a religious organization, make it plain, and then there are a lot of protections for you.
Very helpful. There's a couple more questions. I'm just going to bunch them into one about Christian colleges. How does this affect married student housing at Christian colleges and universities? And how would this affect the ability for these organizations' hiring rights?
So I think we may have already addressed some of that, but it would not be affected. So again, this applies to state actors, and private Christian colleges are not state actors. So there would be no effect on the married student housing or the continued ability of institutions to hire according to mission.
Great, thank you. Okay, I'm going to shift the topic a little bit off Christian colleges. So you've been in the hot seat. So could we talk a little bit about other organizations, and in particular, a question about how does the Respect for Marriage Act affect the organizations who receive federal grants to serve underserved communities? So some examples were given, including things like foster care. And there's about a half dozen questions in here about foster care as well. So if someone want to take kind of the broader question about how the Respect for Marriage Act affects those types of organizations who receive federal grants to serve underserved communities and foster care.
I mean, the general issue is just like with the religious colleges, that this doesn't affect their ability. They don't become state actors because they received grants, contracts, whoever they're serving. Again, it's different in the very narrow set of cases. Running a prison, that's definitely a government function, and you're acting on the part of the government there. And there are a few others. I think the foster care one's more complicated, and I'll ask if Alexander wants to address that.
Yeah, so foster care agencies, religious foster care agencies, do have duties to the government, of course. I mean, they can't do anything they want, with a child. They have not, to my knowledge, been held to be state actors to the present. And that would not change on account of the Respect for Marriage Act. Those are very sensitive things. The state does have power over children in the foster care system. Technically, the state is the one that has ultimate custody, of those children. But any obligations that private foster care agencies might have that pertain to same-sex marriage, they would already have right now. So if they don't have any of those obligations right now, the Respect for Marriage Act is not going to impose any additional obligations on them. And then we also have, and this is important to note, we have a 9-0 Supreme Court decision dealing with this area of adoption and foster care, the Fulton case, the Fulton against City of Philadelphia case, in which the Supreme Court held 9-0 that the City of Philadelphia could not specifically target Catholic social services in their adoption and foster care related activities for adverse treatment because of their beliefs and their practices regarding same-sex marriage and traditional marriage. So that too is a powerful backstop. In addition to that, the Respect for Marriage Act preserves fully intact the Federal Religious Freedom Restoration Act, which again is another very powerful backstop against any kind of attack, based on a foster care situation. So we have multiple layers of protection for those very sensitive situations.
Great, thank you. I'm going to shift a little bit. We've got several questions in here about how this impacts houses of worship. So to kind of go in that direction, are ministers who are licensed by the state to perform wedding ceremonies considered to be government actors, or how does the Respect for Marriage Act impact these ministers who perform wedding ceremonies?
Well, I directly represent churches, and I can tell you they are not considered to be state actors. Okay? Those who solemnize marriages on behalf of private religious organizations have never, in any case that I'm aware of, been considered to be state actors. Now, just to make sure, belt and suspenders here, the Respect for Marriage Act explicitly states that no such religious organization and no employee of that religious organization can be required to provide services, I'm reading now from the text, accommodations, advantages, facilities, goods, or privileges for the solemnization or celebration of a marriage, and that any kind of refusal to solemnize such a marriage or to provide such services by such a religious organization or its employees would not be actionable in law. That is, you couldn't sue someone for refusing to solemnize a gay marriage or refusing to accommodate or serve a gay marriage if you're talking about a religious organization or someone who works for that organization. So churches are not going to be required in any way, shape, or form to solemnize or support same-sex marriages. And that, by the way, is a new protection in the law. So that currently doesn't exist. And that would be added as a statutory matter. So there are constitutional protections already, of course, but this would be added as an express statutory matter by the Congress of the United States. That's very powerful. And that is a new protection that goes beyond the scope of what the RMA itself is really addressing. It's sort of just an added on protection because the RMA itself doesn't require religious organizations to host same-sex marriages anyway. But this was just an added sort of sweetener for the faith community.
Yeah, you anticipated a question that's been asked in the chat. I'm going to ask it again just to make sure that the person has clarity on what the answer is. So the question is, we have a substantial wedding venue at our campus for our house of worship. And because this venue is open to the public, we're concerned that a same-sex couple could request to have a wedding here. And if we do not let them, that we could be sued. And Alexander or anyone, could you just speak directly to this person's concern?
Let me just mention just briefly, and then I'll yield the floor. Explicitly set out in the list of organizations that do not have to participate in any way in a same-sex celebration or same-sex solemnization is, quote, religious educational institutions. The law would explicitly say that you do not have to host same-sex marriages or same-sex celebrations, and so forth. So that again is a very significant protection.
I think it's worth just stressing here too that the very design of this amended bill, the way it is, from a finding that says there are different respectful views about marriage that people can hold, and to these very itemized protections that are in there, Congress is explicitly saying we are not saying that everybody has to believe that same-sex marriage and opposite-sex marriage are equal. We're actually saying to government officials, you have to respect same-sex marriages in certain contexts, but we accept that there are other ways of doing this, and we want to protect people and organizations that have other ways. That's kind of written throughout the bill. So that goes entirely against the idea that now, because this is passed, somebody can come along and just say, oh, now everybody has to accept same-sex marriage. That's like the very opposite of the way the bill is constructed and what it says.
Yeah, and just one more note in addition, opening up your chapel or church fund does not terminate its state
Okay, thank you. I want to try to squeeze in 3 more questions here at least. So thanks for everyone who's asking them. I promise you, as I said at the top, we're not going to be able to get to them all, and I'm sorry. In order to qualify under the protections that are being put forward in this amended version of the Respect for Marriage Act, what documentation is required in terms of bylaws? Does an organization need to clearly state their beliefs regarding marriage, or are clear statements of general religious belief enough?
I'm a big fan of greater clarity. So as I advise religious organizations, I think it's important that they, in their founding documents, in their governing documents, that they state very clearly their religious mission, their overall vision, to the extent they can insert those kinds of things, and to the extent that you're going to be dealing with some of these same-sex marriage related issues, to set forth very clearly your doctrine in that regard, and then to have policies that are consistent with that doctrine, so that when you do face legal challenges, and they're not going to come from the Respect for Marriage Act, but when you do face legal challenges, that you are in a position to say, court, this is what we believe, we act consistent with our beliefs, and therefore we are entitled to constitutional and statutory respect for the practice of our beliefs. So I think the day, the days when you can just leave all these things ambiguous and just kind of have a general, kind of generalized Christian mission without any real specifics, and then have policies that really don't track those important doctrinal statements. I think those days are now over, or at least they've become quite a bit more dangerous. I think people would be well served. Religious institutions, and especially religious colleges, would be well served to spell out very, very clearly their religious mission, and then to have policies that implement it. And in any areas where you think you might have conflict, to spell out your policies and to root them in Scripture, root them in your belief and the teachings of your faith community, and then truly follow them. That will be the strongest way to present your case to a court and allow you to say that this is truly burdening my religious exercise, our faith community's religious exercise, and we're entitled to protections.
Yeah, can I just add to that, this kind of exercise of thinking through what it is that the organization actually believes is entailed by its convictions, and then making sure that policies fit with that is a good practice just for your own mission integrity. It's also vital for legal reasons, but it's really important. So everybody in the organization knows what they should be about and why they're doing this instead of doing that.
It also gives you a basis to ensure that your teachers and professors and employees and so forth, are all on the same page.
Yeah.
And if they don't support the mission, then perhaps they need to look for other opportunities.
Thank you. Someone's asking, and several people actually have asked a similar question to this. How does this law relate to laws that exist in the states currently that are potentially conflicting laws?
Well, Obergefell, the gay marriage decision, overrode local traditional marriage only laws, and this continues in that vein. So if you're I'm in Utah right now. The state of Utah has a constitutional amendment saying that only marriage between a man and a woman is recognized. That is overridden by the Obergefell decision, and likewise would be overridden, at least for purposes of recognition of other states' marriages, by the Respect for Marriage Act. So there is that piece of it. The provisions that protect tax-exempt status and these other kinds of of benefits, the way this is phrased is that nothing in this act should be construed to deny or alter any benefit, status, or right that an organization or an individual might be entitled to. So that is a focus on this act itself, and that particular provision is not addressing other things that state laws might do. However, this provision that we've talked about that says that a religious organization, a religious college, for example, can't be forced to host same-sex marriages or their celebrations, that is not limited to federal law. And the way that is drafted, it is expansively inclusive of all law, and so that's a fairly broad protection. So not just against the federal law, but also against state and local law.
Great. I'm going to take them until we're done. If the Senate goes ahead with this amendment with the religious freedom language, it will go back to the House. Could they take out the language and pass the act without it?
If they did that, then it has to come back to the Senate because it wouldn't be the same bill. So it can't be enacted. If the Senate passes something, the House has to pass the same thing for it to become law. So if the House then takes it back out, then I think the Senate would just say, that's not our bill. We're not going to pass that version. That's what they've already said.
And we believe, though, that is not going to happen, that it will be passed immediately. The House of Representatives, of course, is a much easier place to get something passed. The majority can simply schedule a vote and preclude any amendments, and there's just an up or down vote on it. They can do that within a matter of hours almost.
And this is going to be my last question because I know it's going to be a long answer. There have been several questions asked, some very deep into the weeds. So I apologize, I can't get as deep as the questions have been specific. But raising questions about folks who have sincere religious freedom concerns that have been critics of the bill, and would like to hear a little bit more about why the folks who are gathered on this call feel confident in the sufficiency of the Religious Freedom Amendment that's been put forward by Baldwin and Collins, where there have been critics who have said that it's not sufficient.
Well, I think we heard kind of an explanation that Alexander went into a lot of detail about what the bill does and doesn't do. And I think that's what has convinced us. There are some other efforts out there to say, let's amend it further and so on. I think, any better language, to the extent it's possible, language can often be improved, is a good idea, but it's very hard to get into a bill, protections against things that aren't in that bill itself. So I think that's one real challenge here. And I would just say that, religious freedom legislative provisions only are effective and protect religious freedom when they are part of an enacted law. And so it's okay to say we wish it had a lot of other things. The question is, can you get 60 votes for a lot of other things? And so here we have a bill that has certain limited provisions. It has certain very robust religious freedom protections. And we think that that makes a very strong package for religious freedom, improving the situation that exists at the moment. And that's a very strong thing to happen if that ends up being actual part of the United States law.
I think it's notable as well, Stephanie, that there are some very prominent legal scholars, scholars that I consider to be the most prominent religious liberty scholars in the nation, who have come out strongly in favor of this bill and its religious freedom protections. Professor Douglas Laycock, one of the preeminent advocates in front of the Supreme Court, and also a scholar in this area for many, many years, who's won some of the most important religious freedom cases in front of the Supreme Court in decades. Professor Carl Esbeck, who may well be on this webinar, has also written a beautiful piece explaining the protections that the Respect for Marriage Act provides. And there are others, Tom Berg and Robin Fretwell Wilson. These are people who practice in this area, who write in this area, and who are deeply, deeply concerned about religious liberty. They have lengthy pedigrees. Some of them are people of very deep faith and traditional faith. And they have reached the same conclusions that we have, as we have looked at this very, very carefully for months now, that these protections are valid, they are strong, and that this is a way forward. That instead of having perpetual conflict with the LGBT side of things, that we find some ways where we can at least have our rights protected as they are advancing theirs, and maybe turn down the temperature just a bit in this culture war so we can live together in peace.
Yeah, I think the only thing I would add is just kind of a reiteration that the RMA is a more narrowly tailored bill that addresses marriage. And so while the religious liberty protections do not address every possible conflict out there, they're proportionate to the bill. And so, yes, all of us on this call have been involved in conversations about ensuring those broader protections. We want stronger protections too. And so that's not something we're going to stop advocating for because the RMA has religious liberty amendments. But we get good language now, then we're arguing from a position of strength.
Thank you. Thanks to each of you just for your wonderful explanations, for the questions on the call. Thank you for everyone who joined today, for your excellent questions. And again, I'm sorry that we couldn't get into them all. I hope we created clarity for folks. We had a lot of folks asking very specific questions pertinent to their organization's ability to remain free to serve. And we're really grateful for you asking those questions. We'll send the recording as a follow-up and the resources that were shared today. And we will look forward to the opportunity to connect with you again in the future. Thank you.